representations by counsels, post-argument procedures, and other related matters. While the Solicitor General has inhibited himself from the Poe cases, the Court will nonetheless notify the Solicitor General and require the Solicitor General to give his views in these two cases. Second item, in the matter of GR number 212426, Rene A.V. Sagizag et al. Versus Executive Secretary et al. And GR number 212444, Bagong Alyansang Makabayan, as represented by Secretary General Renato Reyes et al. Versus Secretary of National Defense et al. The Court voting 10-4-1 in a decision written by the Chief Justice with a separate concurring opinion by the Senior Associate Justice with 4 dissenting justices, specifically Justices Leonardo de Castro, Justices Brion, Justice Perlas Bernabe, Justice Leonen, with Justices de Castro, Brion, and Leonen issuing separate dissenting opinions, and with Justice Hardaleza taking no part, rendered the following judgment. Quote, as it is, EDCA is not constitutionally infirm. As an executive agreement, it remains consistent with existing laws and treaties that it purports to implement. Wherefore, we hereby dismiss the petition, unquote. The Court upheld the constitutionality of the Enhanced Defense Cooperation Agreement, EDCA, between the Philippines and the United States on the ground that Article 18, Section 25 of the 1987 Constitution allows the President to enter into an executive agreement on foreign military bases, troops, or facilities if A, it is not the instrument that allows the presence of foreign military bases, troops, or facilities, or B, it merely aims to implement an existing law or treaty, and holding that the EDCA is one such executive agreement. In so ruling, the Court disagreed with the Senate's position, which had been submitted to the Court by way of Senate Resolution number 105, expressing the view of the Senate that the EDCA must be submitted to the Senate in the form of a treaty for concurrence by at least 2/3 of all the members of the Senate. The Court provided the following reasons. A, the President's power to enter into executive agreements, which is different from treaties, not requiring Senate concurrence, has been well recognized and long upheld by the Court. B, the Mutual Defense Treaty continues to be a valid treaty, which the Court has as recent as the year 2009 recognized. C, a plain reading of the text of the constitutional provision in Article 18, Section 25, leads to the conclusion that it applies only to a proposed agreement between the Philippines and another foreign government, whereby military bases, troops, or facilities of such foreign government would be, quote, allowed, unquote, or would, quote, gain entry, unquote, into Philippine territory. The Court ruled that the EDCA is not the instrument that allows U.S. troops or facilities to enter, as the Visiting Forces Agreement already has done that, citing its earlier decisions. It also stated that, as per its earlier decisions, the Constitution of the Philippines continues to govern the conduct of foreign military troops in the Philippines. The Court noted that the EDCA provides for arrangements to implement existing treaties allowing entry of foreign military troops or facilities, specifically under the VFA and the MDT, and thus may be in the form of an executive agreement solely within the powers of the President, not requiring Senate concurrence under Article 18, Section 25. The Court pointed out that no court can tell the President to desist from choosing an executive agreement over a treaty to embody an international agreement unless the case falls squarely within Article 18, Section 25. In the field of external affairs, the President must be given a larger measure of authority and wider discretion, subject only to the least amount of checks and restrictions under the Constitution. Accordingly, in the exercise of judicial review, the Court does not look into whether an international agreement should be in the form of a treaty or an executive agreement, save in cases where the Constitution or statute requires otherwise. Rather, in view of the vast constitutional powers and prerogatives granted to the President in the field of foreign affairs, the task of the Court is to determine whether the international agreement is consistent with the applicable limitations. The Court summed up its framework in resolving this issue in the following manner. Section 25, Article 18 of the Constitution contains stringent requirements that must be fulfilled by an international agreement allowing the presence of foreign military bases, troops, or facilities in the Philippines. If the agreement is not covered by the above situation, meaning Article 18, Section 25, then the President may choose the form of the agreement, i.e., either an executive agreement or a treaty, provided that the agreement dealing with foreign military bases, troops, or facilities is not the principal agreement that first allowed the entry or presence in the Philippines. The executive agreement must not go beyond the parameters, limitations, and standards set by the law and/or treaty that the former purports to implement, and must not unduly expand the international obligations expressly mentioned or necessarily implied in the law or treaty. The executive agreement must be consistent with the Constitution as well as existing laws and treaties. The Court noted that the President's choice of an executive agreement to contain the EDGA places the burden on respondents to show that it is a mere implementation of existing laws and treaties already concurred in by the Senate. On this, the Court found that the burden had been discharged by the respondents. Third item. In the matter of GR number 211140, Lord Alan J. Q. Velasco versus the Honorable Speaker Feliciano Belmonte Jr., Marilyn Barua Yap, and Regina Onshaco Reyes. The Court voting 8-1-6. The decision written by Justice Leonardo de Castro, with a separate concurrence by Justice Leonen, with a separate dissent by Justice Brion, with the following justices taking no part: Justices Velasco, Peralta, Del Castillo, Mendoza, Perlas Bernabe, Hardeleza. Rendered the following judgment. Wherefore, the petition for mandamus is granted. The public respondents, Honorable Feliciano R. Belmonte Jr., Speaker, House of Representatives, shall administer the oath of Petitioner Lord Alan J. Q. Velasco as the duly elected.
At yan po ang press conference ng Korte Suprema sa pangunguna ng tagapagsalita nitong si Attorney Teodorte. Pinagtibay ng Korte Suprema ang constitutionality ng Enhanced Defense Cooperation Agreement o EDCA sa botong 10-4-1. Ayon sa Korte Suprema, may kapangyarihan ang Pangulo na pumasok sa mga executive agreement kung ang layon lang nito ay para ipatupad ang isang existing agreement o treaty. Matatanda ang iginiit ng Malacanang na layon lang ng EDCA na pag-ibayuhin ang pagpapatupad ng Mutual Defense Treaty sa pagitan ng Pilipinas at Amerika. Sa ilalim ng kasunduan, pinahihintulutan ang mga tropang Amerikano na magsanay, magkarga ng langis sa mga eroplano at magposisyon ng mga supply sa teritoryo ng Pilipinas. Samantala, sa iba pang kaso, pinagtibay ng Korte Suprema ang temporary restraining order sa mga disqualification case laban kay Senadora Grace Poe sa botong 12-3. Nagdesisyon din ng Korte Suprema na pag-isahin na lang ang lahat ng kaso laban kay Poe.